I'm Bob Schwartz, and I'm coming to you today to talk about the Zantac litigation for our first quarter 2026 newsletter. The MDL judge in this litigation issued a 341-page opinion in December of 22 striking plaintiff's general liability expert. The judge said the methodologies employed by the expert were flawed and unreliable. The decision affected over 50,000 pending claims. All were dismissed. The plaintiffs then appealed that decision to the U.S. Court of Appeals for the 11th Circuit, and oral arguments were held in front of a three-judge panel there on October 10th of 2025, and the court then ruled for the plaintiffs. The panel showed skepticism toward the lower court's approach in striking the expert, and one of the justices said that the lower court may have been a bit too thorough in its review of the expert's opinions, noting that some of the things Judge Rosenberg, the MDL judge, criticized the experts for appeared more fit for a jury to decide after cross-examination, as opposed to being decided as a gatekeeper of the scientific evidence. The panel also disputed arguments that the manufacturer defendants made that federal law supersedes the consumer's negligence claims. That's called preemption. And it appeared also to support the validity of the arguments that the companies failed to ensure that the Zantac products were properly handled, properly stored, and properly transported. So the claims could be reinstated. I've seen this a number of times in other MDLs that our firm has been involved in, and the cases might be remanded to this district court, the MDL court, for further proceedings under a corrected legal standard. There is still some activity in the MDL on the non-qualifying cancer cases. If the other cases were remanded back, it would be interesting to have the qualifying cancer cases in with the non-qualifying cancer cases. And so we'll see what happens. There are cases where the judge already found that scientific literature did not support a causal connection between Zantac and these cancers, and that being the case, they are not likely to succeed, but we'll see. There are state courts that have Zantac litigation. In February of 2025, an Illinois state jury ruled in favor of Boehringer, rejecting plaintiffs' claims that Zantac contributed to prostate cancer. And prostate cancer claims in the Zantac litigation, of course, are weaker than some of the other cases, such as involving bladder, esophageal, and stomach cancer. SmithKline Beecham, also called GlaxoSmithKline, reached private settlement agreements covering approximately 80,000 Zantac cases for an estimated $2.2 billion. And Pfizer and Sanofi have also since reached settlements in the Illinois litigation, but the claims against Boehringer continue. The Supreme Court of Delaware sided with the manufacturers on July 4th of 2025, throwing out all plaintiffs' experts and affecting 75 plaintiffs' claims that the carcinogen NDMA in Zantac causes their cancer or caused their cancer. Anyway, there is a lot still going on. It's going to be very interesting to see what happens to the 50,000 cases that were dismissed. But we will let you know when we find something out. If you have any questions, you can always contact us through our website, bcaclients.com. Thank you.
You've been watching a litigation update with Brent Kuhn and Associates. Brent Kuhn and Associates is a nationally recognized law firm and the epitome of the 21st century law practice. The firm has built its reputation on the satisfaction of its clients and the respect of both colleagues and opponents. Our mission is to help ensure that individuals' rights are protected and their well-being respected. For more information about Brent Kuhn and Associates and current litigation, please visit bkuhnlaw.com.